Harry here with the latest in the saga involving the Texas House and the efforts of the Republican majority to force the Democratic minority to return and basically sit there while the majority redistricts, adds 5 seats, makes everything harder for Democrats across the nation in the midterms. And really, this has been, as I've said before, the rule of holes. If you're in a hole, stop digging. The latest is that the House of Representatives brought a lawsuit in Illinois, and it said, we majority issued these warrants saying, bring back the Democratic representatives, and you, Illinois, need to enforce them as a matter of full faith and credit under the Constitution. Now, full faith and credit generally applies to judgments. They have a creative argument in here that says in order to really fully get full faith and credit, you got to be able to sometimes do legislative authority as well as, our warrants as well as judgments from a court, and do that here. And the Illinois court gives it, I wouldn't say back of the hand. It's a thoughtful enough, reasoned opinion, but it's really makes it clear that they are barking up the wrong tree, and they are barking up the wrong tree. Just to take a step back, what they are been trying to say, including with these warrants, these special kinds of warrants, is that the Democrats have abandoned their office. That's the claim they are making. And if you look at Texas law, the abandonment of an office is way more definitive, permanent than what they're talking about here. Indeed, this, which has occurred before, is actually the non-abandonment of an office. It's quite clear that the legislators who are now holed up in Illinois are very much still doing their constituents' business by keeping this raw, nasty power play by the Republicans of going forward. So it's really, the claim is all wet to say that, but that's what they're trying to do, to say they have abandoned their office. And now Illinois, where they are, right, they're out of Texas, so there's no jurisdiction over them. Illinois, you come and order them to return. Okay, so the Illinois court issues an order yesterday that says, look, you got to have a case, subject matter jurisdiction, and we don't have it. This is a requested civil contempt finding against the respondents for not going back and for supposedly evading service of Texas legislative quorum warrants in this special legislative session. So legislative warrants. So what they're trying to do is transfer the legislative authority of the state of Texas to the Illinois court to initiate contempt proceedings. But contempt proceedings, as we know, typically inhere in failures to obey lawful, especially judicial orders. And they don't cite any authority to give us anything that we could even try to say the legislators are in contempt. The court notes, the Illinois court says, the cause of action is unique because within the request to find the Texas legislators in contempt for conduct occurring during a special legislative session, the petitioner also requests that this court recognize these warrants that the legislature has voted out as a public act. But while courts will frequently consider petitions because they've been brought before a court, say a petition to show cause, here there is no court order. Petitioner claims that the respondents have violated. You want us to basically find under Illinois law, using full faith and credit, that they have violated a court order. There is no court order. There's no underlying Texas court order that the petitioner seeks to register and enforce in Illinois. That's typically what happens. You have an order that the court recognizes it, and you go and present it to a court in another state. And that's when the, full faith and credit clause of the Constitution. So basically says the Illinois court, they're just seeking assistance for any order to basically effectuate their legislative action. And they want us essentially to initiate the contempt proceedings against respondents. That's not recognizing. They want us to do the dirty work that isn't able to be done in Texas, where we say you're in contempt. No, that's not how full faith and credit works. If they did it, then we might have, and there were an order, and we could determine, yes, they're willfully disobeying a court order. Maybe under full faith and credit, we could say, okay, we're going to send them back. Maybe that's all they say. But, and this is really obvious and why this petition was DOA. This Illinois Circuit Court does not have the inherent power to initiate, consider, and determine whether the actions of foreign legislators, that means foreign is Texas, in a special legislative session, were contumacious, the legal term for being in contempt, and done for the purpose of willfully evading civil legislative quorum warrants issued by the state. So that's that's part of the point that they've made in Texas. This is a statement. This is a judgment based in part on what's in the heads of the Texas legislators. If that had already been fully determined in Texas, that'd be one thing. But please don't come to us and ask us to pretend we are Texas courts and apply Texas law and decide, Texas facts and the like. So, as the petitioner has failed to present a legal basis for the court to obtain subject matter jurisdiction, this court is without jurisdiction. And so, that's the end. We don't have the ability to hear the cause itself. So it doesn't matter whether we possibly have the even the personal jurisdiction over these folks. Okay. Just to close with a little about where are we now, right? So they leave, and you have steam coming out of the ears of the governor, Abbott, he's the one who's trying to file this a motion like this in the Supreme Court. At the same time, the Attorney General, it's all caught up in Texas politics. Ken Paxton is saying, oh, the governor can't do this. I'm the one who has to. At the same time, the Texas senator who is running against the Texas Attorney General in a Senate primary is saying, I'm getting the FBI on the case. And the real point is the Texas Democrats have done nothing wrong. They've acted in a somewhat extraordinary way, but employing the remedy that exists when you're in a minority and the majority is over and over and over again trying to shove it down your throat. This is one of the things they can do. It's recognized. It's happened before. So really, the Republicans are without a leg to stand on when they're trying all this legal stuff, or just trying to talk tough, shame the Democrats. And by the way, it is the case. And the Dems have reported they're getting death threats and all this stuff from, the crazy MAGA sympathizers. And there's always a worry about lone wolves and the like. They're spending money. They're coming into holidays. So in the short term, the legal ability for the Texas Republicans to force them back, and by next Tuesday, which is when the special session ends, looks remote. But there's nothing that will prevent the governor from calling another special session. And then do they flee? I mean, in the short-term skirmish, the Dems are just better positioned on the law, but in practice, their ability to really sort of hold out indefinitely here, meaning the end of the year, until the time when it's just impossible legally to do anything that would affect the midterms. That's the game here. Get 5 more Republican seats for the midterms, which are predicted right now to go strongly in the Democrats' direction. There's still a long road to hoe for the Dems. It's not clear that they can do it as a practical matter. Legally, however, notwithstanding all this outrage and ire and attempted petitions and the like from the Republicans, they're basically all wet, and they don't really have and haven't been able to find, even as they've continued to flail, a basis for forcing the Dems to return. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.